unanimous consent that the quorum call be dispensed with.
Without objection.
Thank you, Madam President. As the Senate knows, this week we will be voting on a bill called the Respect for Marriage Act. Tonight we'll vote on a procedural matter to move that legislation along. Supporters of this legislation have framed it as a way to protect the right of same-sex couples to get married in any state in America. To be clear, that is already the law of the land. It's been so since 2015 when the Supreme Court ruled in the Obergefell case, and there's no reason to believe that this decision is in any imminent jeopardy. Some colleagues have tried to claim that because of the Supreme Court's decision in the Dobbs case, which overruled Roe versus Wade, that somehow that's opened the floodgates of the Supreme Court to overrule all of the precedent that it disagrees with. Well, the justices in their concurring opinions in Dobbs made clear that's not true. For example, they mentioned landmark precedents like Griswold versus Connecticut, Loving versus Virginia, and notably Obergefell versus Hodges. One judge wrote, "I emphasize that what the court today states, overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents." I don't know what more the Supreme Court could say to indicate that Obergefell is not threatened by this court anytime soon. So I'm left with the conclusion that this idea that we have to pass this legislation in order to preserve what has already been recognized by the Supreme Court as a constitutional right, that this is based on, frankly, a scare tactic. Nevertheless, some of our colleagues claim that this legislation is absolutely necessary. But while this bill does not move the needle on same-sex marriage, this legislation will raise serious issues for religious liberty. We all know that many Americans hold sincere beliefs, religious beliefs, objecting to same-sex marriage. Obergefell did not place any new requirement on those individuals or their religious institutions. The Obergefell decision coexists today with other Supreme Court precedents like Masterpiece Cake Shop or Fulton versus City of Philadelphia or Burwell versus Hobby Lobby. Each of these decisions recognized that religious liberties shall and must be protected as required by our Constitution, namely the Equal Protection Clause and the Free Exercise Clause. For example, Obergefell doesn't compel Catholic priests or Jewish rabbis to conduct marriage ceremonies for same-sex couples. But it certainly doesn't subject religious organizations or faith-based institutions or even private citizens to lawsuits for exercising their deeply held religious objections to same-sex marriage. If the Respect for Marriage Act becomes law, as it is currently proposed without amendment, that would change. Unlike Obergefell, this legislation expressly empowers private litigants to sue religious institutions, faith-based organizations, and private parties who oppose, for sincerely held religious beliefs, same-sex marriage. Think back to the Masterpiece Cake Shop lawsuit. The owner of a bakery in Colorado declined a request to make a wedding cake for a same-sex couple because it didn't align with his religious beliefs. If this legislation passes, we can expect similar lawsuits by secular warriors targeting people from cake bakers to florists to website creators to venue owners or just about any other small business that doesn't bend a knee to their worldview. But it's not just individuals with deeply held religious beliefs who will have a target placed on their back. It's also religious institutions themselves. I'm not talking about churches or synagogues or mosques. I'm talking about many of the faith-based social service agencies, non-governmental organizations, and charities that are supported by people of faith as part of their mission. Well, this legislation would permit a private lawsuit against, let's say, an institution of higher learning, like a major university, or your child's preschool or Mother's Day Out. It includes religious charities and nonprofits that carry out incredibly meaningful and important work. And it includes anyone acting, quote, under the color of state law. Now that's an interesting choice of the scope of this right of a private right of action, anyone acting under the color of state law. This is a very broad term that comes directly from the text of the bill, and it's not clear entirely who would be subject to this provision. If a person receives a professional license from their state to serve as a lawyer, an accountant, a bartender, a realtor, or a barber, are they acting under color of state law? I think that's a plausible argument. If a nonprofit receives public funds to perform a service on behalf of the government, are they acting under color of state law? It's not clear, and it needs to be clear. The range of people who can be sued will only be limited by lawyers' imaginations. Trial lawyers in the Biden Department of Justice could have a field day. Individuals and organizations that are trying to do good works consistent with their faith would be forced to spend a small fortune defending themselves in court, just as the owner of Masterpiece Cake Shop did for 10 years. This legislation could open the door for the government to take serious action against religious institutions for adhering to their sincerely held religious beliefs. The federal government could deny grants for research to colleges and universities like Baylor University, Southern Methodist University, or Texas Christian University in my state. Faith-based groups, non-governmental organizations could be barred from working with the federal government to take care of the tens of thousands of unaccompanied children that are coming across our border as part of the current border crisis. Cities and states could deny foster care permits and licenses to religious organizations that do an immeasurable amount of good, including Catholic Charities, Little Sisters of the Poor, or Buckner International. The Internal Revenue Service could seek to revoke the tax-exempt status of organizations that fail to comply with this new secular mandate. Now, lest you think that this is a fever dream or a conspiracy theory, let me just take you back to the Obergefell arguments. Justice Alito asked the Solicitor General if an institution that opposed same-sex marriage could lose its tax-exempt status. The Solicitor General said it's certainly going to be an issue, and he was correct. And now the issue is front and center. Now, I believe that the sponsors of this legislation sincerely believe that the consequences I'm describing will not follow. They may believe in good faith that they have protected the free exercise of religion and religious liberties, but I don't believe they've been successful in doing that. That's why I believe that the amendments that have been proposed by Senator Rubio, Senator Lee, and Senator Lankford should be voted on to make clear what I think the sponsors of this legislation intended to do, but weren't quite successful in clearly accomplishing. Well, just remember the IRS has virtually unlimited authority to target religious schools, nonprofits, and organizations by revoking their tax-exempt status, leaving them to the dead end of ruinous and years-consuming litigation. Now, this isn't, like I said, a far-fetched conspiracy or an unrealistic doomsday scenario. We've seen what a politically motivated Internal Revenue Service can do. Perhaps we all remember the IRS targeting controversy under the Obama administration. Under the leadership of Lois Lerner, bureaucrats subjected conservative groups to a different level of scrutiny when examining their tax-exempt status from left-leaning groups. Employees at the IRS actually developed a spreadsheet that became known as a Be on the Lookout list, or simply the BOLO list. If the name of the political group included terms like Tea Party or Patriot, it was subjected to a different level of scrutiny. These IRS bureaucrats delayed the approval of these organizations' tax-exempt status and requested completely unnecessary information. It asked some applicants to disclose the name of their donors, as well as the amounts of each donation, which is constitutionally suspect. A pro-life group was even asked to provide the percentage of time that the groups spent on prayer groups compared with their other activities. Well, this IRS targeting scandal happened about a decade ago, but since then, the IRS has been given even more power and more authority. The most recent reckless tax and spending bill, the so-called Inflation Reduction Act, gave the Internal Revenue Service an additional $80 billion and 87,000 new IRS agents. This army of new agents would have the capability to turn its attention on every church, school, and organization that did not recognize same-sex marriage because of their sincerely held religious beliefs. So you have to wonder, who will be on the BOLO list next? Given everything we've seen, the experience we've had in this area, I can't say I have much confidence in how this will be handled. So, to summarize, this legislation does not move the needle in terms of the rights of same-sex couples. They can already marry in every state in the country, and this bill doesn't change that. What it will do is force religious organizations to make an impossible choice: abandon your beliefs or face the wrath of the U.S. government. So, let me just repeat what I said a moment ago, Madam President. I believe the proponents of this legislation thought they were protecting and preserving the religious liberties of people with sincerely held religious beliefs. But when they include a private right of action for someone acting under color of state law, it refers to any public act, any right or claim. And as I said, you can interpret color of state law to cover everything from professional licensing to teaching certificates to building permits to food and beverage licenses. So I think that if the proponents of this legislation really believe that protecting religious liberty should be our goal, the best way to accomplish that is to allow votes on these amendments by Senators Lee, Senators Rubio, and Senator Langford, who provided an extra clear assurance that this legislation does not constitute a national policy endorsing a specific view of marriage. I know it may sound like a simple clarification, but it could mean the difference between faith-based nonprofits ending up in the crosshairs of the IRS or some private party lawsuit claiming they're operating under color of state law, and the ability to maintain their tax-exempt status or carry on the important good work that many organizations do in our communities all across the country. So if that indeed is the purpose of our colleagues, to try to protect those religious organizations, those people of faith who are doing good works that we want to encourage and we want to support, then I believe that we can accomplish their goal by passing the amendments that have been proposed by Senator Lee, Senator Rubio, and Senator Langford. If that is their goal, they shouldn't have any objection to this clarification. But we simply can't stand by and allow this legislation, or any legislation for that matter, to foot stomp the First Amendment rights of people of faith. Unless this bill is amended, it will invite a wave of lawsuits against churches, synagogues, mosques, religious nonprofits, simply because they're living in accordance with their faith. One other thing I should point out that was mentioned by the U.S. Conference of Catholic Bishops, in the one area that I would call it a safe harbor to protect religious liberty, I think it's 6B in the bill that's been offered, the protection of religious liberty that, again, I think our colleagues in good faith intended to provide is limited to those whose principal purpose is the study, practice, or advancement of religion. So that clearly would involve things like church services or religious observations at a mosque or a synagogue. But would it cover a church's daycare facility they provide for the children whose parents attend their church? Would it cover universities like I mentioned earlier, Baylor University, a Baptist university, Southern Methodist University, Texas Christian University, and the work they do? How about Catholic Charities? That's one of the principal provider of humanitarian services at the border that have resulted due to the border crisis that we are experiencing. None of those would be protected, I would argue, under the limitation in Section 6B. And this was actually pointed out by the U.S. Conference of Catholic Bishops. I think they're right. But again, if the goal of the bill is to preserve religious liberty, I think the bill needs to be amended. Religious liberty is a cornerstone of our democracy. It's explicitly protected by the United States Constitution, and we cannot allow it to be trampled on. Madam President, I yield the floor, and I note the absence of a quorum.
The clerk will call